everybody. Welcome to Supporting Clients Around Inclusion on the CACI. I'm just going to go, oops, to the next slide. The learning objectives today, I'm going to do a description of how the CACI works, what the process is, what's reportable, and then go through consequences of a listing and what you can do about it. Just because most people, I believe, who are attending are legal aid attorneys, I just want to give a sort of macro description of what happens with the CACI. It is a very lengthy registry with not a lot of options to get off. So one of the reasons that we have targeted legal aid attorneys is because there also isn't any representation, and it's an extrajudicial process. So we are hoping that with more awareness of it, more people can be helped to challenge their listings. The handouts that LAAC will pass on to you include a statewide audit that went through in 2022. The basics of the audit, just so you know, it's good to have it in case this is of interest to you, but the basics was that the state audited the entire child welfare system for CACI and specifically sampled a select number of counties where they did a more in-depth look of whether people were being put on the Child Abuse Central Index when they were supposed to be, and whether the processes were working. And the answer to both of those, according to the audit, was no, that there were many, many people who qualified under the definition of the CACI and hadn't been put on, and then that there were some people that had been put on that shouldn't have been put on. And also like a pretty rigorous critique of the process, which is, it's going to be pretty clear to you why they critiqued the process when we described it. The next thing that you have is the 4 forms that are associated with being put on the CACI and the ones that go to the actual listees. So the indexing form is what is sent to list you on the index, and then these 3 other forms are what you get in order to understand that you've been put on it and an explanation of what you can do to try to fight that. The third thing is the manual of policies or procedures. It's a very small section that explains how CACI works and how you would challenge it. And then there's 2 cases. The reason that this is so extensive is just in case any of you are in reentry and you decide you really want to do a CACI case. I just want you to have everything that you could access to do that. The 2 cases are Gonzalez, which is a parental discipline privilege case, meaning it is one where a parent was put onto the CACI and for disciplining their child physically, and then they were raising the privilege in order to be off the CACI. And then Henry DP was our most recent Supreme Court case on CACI. There's also one this year, which specifically will have something to do with clarifying the responsibility of notice, which we can talk about some other time, or you can contact me. And the last is a collateral consequences letter sample. I'm going to come back to that when we're talking about things you can do to help clients. So first thing, what is the Child Abuse Central Index? The Child Abuse Central Index is in the sections of the penal code that are listed in the slide, which you can very quickly become an expert because there aren't many of them. But this is the description that's actually from Penal Code 11170. It's an index of all substantiated reports of child abuse and severe neglect submitted to the Department of Justice. It started in 1965. The purpose of the CACI originally was to help doctors and law enforcement agents catch people who did repeat child abuse and then moved jurisdictions. So people who were, for example, switching hospitals to avoid suspicion or moving because they had been under investigation by the police. That was its original purpose. It was pretty narrow, and the way to get on it was narrow. The substantiated report we're going to go into if you're confused, so don't worry about that part. The DOJ is only, quote unquote, a repository of reports. What that means is that they basically just have an index card that has an index card's worth of information that about the person listed. And then if you want to know why you were listed, you have to go to the submitting agency, which is always a child welfare agency. They're the ones who are responsible for keeping the reports against you, making sure they're accurate, and making sure they're complete. So the investigating agency is child welfare. The person who keeps, or the entity that keeps the list, is the DOJ. What you have in that listing is the accused name, the victim name, the name of the submitting agency, so that means the child welfare agency, the case number, and then a brief description of what was substantiated. That could be extremely brief, like it could just say abuse or severe neglect. Occasionally, there will be like a little bit more of a descriptor. Oops, sorry guys. I went. I don't know how we got to this point. Um, we are zooming through. I'm going to go back manually. The CACI timeline, how you come into the Child Abuse Central Index, first there has to be an initial, this is how cases come into the child welfare system as well. First, you get an initial referral. So that is a call that's made to the child abuse hotline. Almost all calls made to the child abuse hotline are from mandated reporters, and most of the way that people end up on the Child Abuse Central Index is from mandated reporters. The two top mandated reporters, and that's actually like pretty high above everybody else, are police and schools. Mandated reports made by police also make it to the investigation stage more often, meaning that they're substantiated more often. The result of this for the Child Abuse Central Index is that most people are put on the CACI because of police interaction in some way, and then they are more likely to have a substantiation because the mandated report comes from the police. At the point that someone calls the hotline and says, I believe that there is severe neglect or abuse, the hotline, the person answering the hotline has to mark it as what they actually believe it is and then pass it on to the next stage. They can either evaluate it out, meaning they don't think that it rises to the level of investigation, or they can refer it for investigation. At this point, which is stage 2, an investigator is sent out, and the standard the hotline uses is basically probable cause. And the emergency social worker will go out to conduct under CACI what is called an active investigation. The emergency worker needs to talk to people in the case. That can be a lot of people. It can be the child's school, the child, parents, neighbors, or it can be like a limited amount of people, but they have to do more than just rely on the information given in, for example, a police report. The emergency worker at this point, so let's say it's for severe neglect, the emergency worker at this point will either substantiate, find inconclusive, or find unfounded the referral. And we're going to talk about the definitions of those terms on the next slide. What's important here is that at this point, if it's substantiated, you move to step 3, where we are going to give the name of the person and the name of the victim to the DOJ for listing on the CACI. And at that point, they will generate the forms and send them to the address of the person who's been listed. What's really important to understand as an attorney for this process is all of this is happening before somebody is represented in any court. So this is the timeline also for a filing in child welfare court, meaning this is what would happen before you have a dependency case filed. It's also what would happen in many cases before a criminal case is filed. So you can end up on the CACI before, in almost all cases, you've had an attorney. And you also are going to end up on the CACI in some cases without anything filed in either court. So sometimes people get Child Abuse Central Index listings and they do not have a criminal case and they do not have a dependency case, meaning they'll never have a lawyer to go over this for. So this is part of why we wanted to talk to legal aid attorneys in case you get called by people who are in a situation where they don't really have anyone to show this paperwork to and are confused. And there are times, and especially since the audit, where we are seeing people getting CACI listings much later. This is because what I told you in the beginning, that part of what the audit said was that there were people who were supposed to be on the CACI who aren't on the CACI. They sent an all county letter saying that all of the counties needed to go through their records and make sure everybody who met the standards that I just described, meaning every substantiated report of severe neglect or abuse, had been sent to the DOJ for listing. So what we're seeing now in like the world of CACI is that people are being listed for cases as late as 2018. We're having people who've had their full dependency case go by. For those of you who aren't dependency lawyers, that's usually like 2 years at least. So we're having people who have had their rights terminated to their children and then just found out that they were listed on the CACI. We'll talk about how that's problematic for due process later, but just keep in mind that there are 2 ways that people who have no access to an attorney right now could be listed on the CACI. One is that the investigation doesn't yield a case in dependency or criminal court, which is actually pretty common. And 2 is that they are part of the reconciliation process from the audit, meaning whatever attorneys they might have had access to, they no longer have access to, which means that there's a high likelihood that they could reach out to legal aid reentry programs, or just hotlines or warm lines that some of y'all have activated out of confusion. The other thing to know about representation in this process is that neither your public defender nor your dependency attorney is responsible for helping you with the CACI. That doesn't mean that there aren't lawyers who are helping their clients with it, but just to know that it's no actual person's responsibility in the legal system. So what does substantiated? Oh, go
It
ahead.
looks like we have a question in the chat. Someone asked, theoretically, should the client receive any notice during steps 1 through 3?
So we will go in detail through the notice. That's a really good question. The thing that I would say that's good to know for 1 through 3 is that you're always going to have notice of an investigation because the social worker is going to show up at your house or pull your children out of school. So that part, people know when CPS is involved. CPS works really hard to tell you that they know you're involved because they want to question you in order to actually meet the requirement of the investigation. There are a lot of notice issues, which we will get to on that slide. Substantiated means more likely than not. It's a preponderance standard that child abuse or neglect occurred. Inconclusive is insufficient evidence, and unfounded is false or inherently improbable, etc. Substantiated is the only one that matters for the CACI. Okay, so this is back to the notice issue. If you guys want, and only because I think the state of California spent a lot of your tax dollars on it, they generated a very beautiful graphic that's on figure 1 of the audit, if you want to reference it, that shows how frustrated they were by this process. This is the detail for how you get listed. The county social worker, the emergency worker I told you, goes out and investigates, substantiates. They enter into their computer system the substantiated. Then they have to manually print a report of the incident, which is the index that I put on your handout. They then send it to their supervisor for changes, and then they manually mail it to the DOJ. There's no electronic system. This is something the audit was very upset about. There's no electronic system for that. And they also manually mail notice of listing or grievance. And the requirement is just mail. There's no personal service. So keep in mind that they're using whatever address that they have, usually based on what the mandated report said. So like if the police put the address wrong, if the police put the address of another party in the case and there's a issue where county welfare doesn't actually know it, if the person is arrested and it's going to somewhere they live, or they have precarious housing, they're not going to get this notice. Like there's nothing more than just mailing it. Then the DOJ themselves has to check for the missing info. If there is anything missing, they mail it back and start the whole manual process over again. If there's nothing missing, they'll list you in the system. The DOJ has no requirements of notice. Their only requirement is to you can fill out, and there's a slide about this, but you can fill out for a self-inquiry to see if you're listed, and they will give you that information. They'll give you what's on the BCAIA 8583. They'll give you the little index. And then if you want any more information, you have to go to the child welfare. So at the point that the social worker sends you to the DOJ, they're supposed to print out these 3 forms and send them to you. As legal aid attorneys, if you look at those forms, you'll see that they're a pretty high literacy level. The font is quite small. The information is confusing. Very few people we do direct representation for people in CACI. Very few people have ever actually understood that they're already listed. So the other important thing is, as soon as they send this to the DOJ approves it, you are on the registry. And the only thing you can do is try to get yourself off. So the entire process is extrajudicial, and it occurs before any judicial process. So keep that part in mind. That once, like I put at the bottom, you're deemed aware of the county decision when the county sends it to your last known address. So we'll come back. Notice is a huge deal, so I promise we're going to come back to that. Who has access to the listing? This has only expanded. If you remember, I told you a brief information about the history of the CACI and what it was intended for. We've just continually expanded it so more regulatory agencies have access to this information. So obviously law enforcement, prosecutors, probation, tribal agencies, everybody making placement decisions for children, including child welfare, but that includes probate court or family court, licensing agencies and employers doing live scans for anything where children are adjacent to it. And I'm going to be a little bit more specific about this part because this is something that people might ask you. Healthcare providers suspecting abuse. I think this is actually, even though it was one of the original intentions, one of the rarest. People who are serving as guardian ad litems or minors counsel, out-of-state law enforcement, or child welfare is also allowed to access the CACI. So we are able to access registries from out of state too in analogous situations. And then anyone who's listed as a victim or accused, you have the right to see your own listing if you fill out a notarized form and send it to the DOJ. So counseling clients, when this comes up, there are people for whom a CACI listing will not have an effect. If you have children, which everyone on the CACI is going to be the caregiver of a child, then it's anything that would involve your child. So any, school volunteering, anything where you're around children. And then live scan employment, including community care license. The actual penal code makes it clear that there needs to be childcare associated with whatever you're doing. Not that you're doing it, but it could be childcare on site. But it's a little bit more ambiguous if you look at the actual form, which when you get the PowerPoint, you can click on these links to go through. It says things like, please note that a CACI check is not required for individuals solely associated to home care organizations or home care aid registry. I have heard of people who were applying to home care aid registries and got that hit, because if you see it says not required, instead of like that you would be restricted from it, which I think is actually like, this is another example of, I actually haven't given you all the examples, but you'll see there are examples where the penal code and the policies aren't really matching. And then the health and safety code background, if you click on that, you can see there are people, if you're going to be providing care to children, the Department of Justice is supposed to give a notification when people are listed. So occasionally you will hear people say that they realized that they were put on the CACI because they lost their employment through one of these without actually a background check. Everyone else is going to have a background check. So for people, like if you're counseling people and they've realized they're on the CACI and they don't have any remedies, which I will describe, and hopefully they have one. But if they don't have any remedies, then they are required to, like, they can make a real choice about how this information gets out if they're like when they decide to background. So occasionally we've had people who just don't have any chance of getting off, and we discuss like, what would it be like to go to your child's school and be flagged? Like, because you can do, and I'm going to mention it now and then later, you can do occupational licensing hearings with the people who are denying you the benefit. But for some people, it's more embarrassing for that to happen and to be known in the school community, for example, than to volunteer to help at the field trip. So there are some like non-legal considerations to talk about when people are making the choice to have a background check. Are you on the CACI? The How you know you're on the CACI, and this is actually the subject of the current, it's one of the questions being asked in the current Supreme Court case. So dependency attorneys, meaning the CPS attorneys, for the parents, they might see it in discovery. If they ask for discovery, discovery in most counties is not automatically granted, so they might not see it. They could ask the administrator of the CACI for their child welfare department. Almost all of the child welfare departments have a person who's in charge of the sort of bureaucratic requirements around the CACI, like making sure they're met, scheduling grievance hearings, etc. And those people will often look it up for dependency attorneys. This is a note just in case you ever represent someone in dependency. It's not really recommended to ask the social worker if your client is on the CACI in case they meet the requirements and haven't been listed. The next part is self-inquiry with the DOJ, which if you click on that link, it'll take you to the actual DOJ listing. And again, I'm just reminding everybody, because of the reconciliation, there is no deadline for listing someone on the CACI. You can be listed on the CACI years afterwards, which we are seeing.
We have another question. I believe they're asking if the timeline for a grievance is 30 days.
We will go thoroughly through the timeline, I promise that part. But the timeline for a grievance, once you receive those forms, but it's worth saying twice, once you receive that notice, you have 30 days to turn in for a grievance hearing. What's important is that if you have a dependency or criminal case ongoing, you will be denied a grievance hearing at that point if jurisdiction has not been taken in dependency court, or if you have not resolved your charges in criminal court. So we'll get back to that part. But what is reportable? Here's the actual CANRA if you decide you want to be an expert on it. It's non-accidental physical injury or death, including unlawful corporal punishment, sexual abuse, severe neglect. What it excludes is mutual fighting between minors, police or school using reasonable or necessary force, and general neglect. It's important to understand that minors do get put on as perpetrators under the CACI, but they have a slightly different set of rules, which we'll get to. On the first, unlawful corporal punishment, here's the actual definition: willfully inflicts cruel or inhuman corporal punishment resulting in injury. Does not include reasonable or necessary force by school or police. Here is the defense to that, which is the Gonzalez case that I gave you guys. It's that corporal punishment is lawful. This is also a defense in dependency court, where there is a genuine disciplinary motive, a reasonable occasion for discipline, and disciplinary measures that are reasonable in kind and degree. And then these are the sort of actual list out of things. Visible bruising is usually the outer limit. People do get put on often for excessive physical discipline. Because this is penal code, you can use any defense that you could use in criminal court, which is different than what you would be able to use in dependency court. One thing that is very confusing for people practicing in the actual agency who is adjudicating these grievance hearings and lawyers or citizens trying to get off the CACI is that the standards under dependency, which is what child welfare spends almost all of its time on, are different than standards under the penal code. And in fact, under the Welfare and Institutions Code, they are much, much, much lower. Like the standard for neglect is quite low, and it doesn't even have a culpability requirement on behalf of the parent. What neglect isn't reportable is general. Here's the definition of general: the negligent failure of a person having the care or custody of a child to provide adequate food, clothing, shelter, medical care, supervision. What makes neglect reportable? So this is most people are going to be on for neglect. So that part's, this is, I'll go through this a little slower. What's important is that we have a heightened intent requirement. So if you remember, I just told you that Welfare Institutions Code 300 doesn't require things to be willful. That's a very famous case, Henry RT, and it doesn't, like, you can have done everything that child welfare will do and you can still be found negligent under the code. Whereas here you could see this is a heightened intent requirement, and you'd also be able to use any defenses from criminal law because it's under the penal code. So the first is, the lowest is for negligent failure to protect a child from severe malnutrition or medically diagnosed non-organic failure to thrive. So that's the lowest. And then here we get to willful harming or injuring of a child or the endangering of the person or health of a child. And then here you have willful, and intentional as the top part. What's loosest in this standard is willfully causing or permitting the person or health of the child to be placed in a situation in which his or her health is endangered. That's difficult because you can do sort of wanton disregard. So that does give like a lot of wiggle room there. So it's not a pure intent requirement. Possible consequences of a listing: failure to obtain employment, loss of license, or failure to obtain a license. The possible exemptions here are if you can occupational licensing hearings, if you can convince the licensing agency that there's a substantial or convincing evidence for a reasonable belief of good character, inability to volunteer, especially at the child's school. And this is one of the most important ones if you understand that the child welfare system is in large part an intergenerational cycle of poverty. So many families in the foster care system were in the foster care system when they themselves were children, and other people of their families are also targeted, similar to incarceration. That it means that years later, you might have issues being a family placement for your own children or for someone in your family. Possible use in discretionary decisions for immigration. I guess given the cultural climate today, I would put an extra star on here because it is a way that when a decision is discretionary, you might be able to tip the scales. Again, the DOJ will only give you the listing, so you are responsible for getting the information. The people making the decision are supposed to request from the child welfare agency the actual file and make an independent judgment, which we will talk about. But it's important to know that you yourself will need to craft a narrative about that. So you will need to see the actual underlying files. So if you had done, for example, a self-inquiry, because the notice requirements that I described with printing things out and sending them through snail mail go very badly, many people only realize they're on the CACI after they try to do one of these things. So you will often have people calling who are completely surprised and had no idea that they were listed. On one hand, it's good that it doesn't come up at every moment of your life. On the other hand, there should be a higher notice requirement for a registry for child abuse. And this is the main reason why there should be a higher notice requirement. Listings will last until an adult is 100 years old. So there are no expungement options. We only have the grievance hearing. Or there's no other expungement options. There's no clean slate. There's no, I've reformed, can you take me off now? You have to win the grievance hearing. And the only way to win the grievance hearing is to say you do not fit the standard of CANRA. So you can't do something that you might do in dependency court or a diversion that you might have in criminal court. You have to say, I don't actually fit this standard in order to win. So it's very limited amount of success or possibility of success in the grievance hearing. And then the other end, there's no other way to challenge it as an adult. I guess if you're still wanting to volunteer at your child's school, or I guess your great grandchild's school at 100 years old, you can, go and ask to be taken off the CACI. That's not automatic, by the way. When you were 100, you would have to go and petition to be taken off. The next part is if you're a juvenile and you're listed as a suspect or perpetrator, you can be removed 10 years after the incident if no subsequent report is filed against you. Now, against report, so there might not be any court that's deciding it. It might just be an allegation put in, for example, your own parents' dependency case if they had a second one. Victims can ask the DOJ by notarized letter to remove their name after they turn 18. I've never heard of anyone doing this. I don't think it's widely known by children that their names are on the registry. Challenges and remedies. Again, expungement options are only for the youth suspects or victims. You negotiate, the remedies are you would negotiate with the investigating agency and DA. You can win a grievance hearing, or you can do a writ of mandamus after you lose your grievance hearing or after you're denied the grievance hearing. After CACI, your remedy is the occupational licensing or administrative hearing over the denial. I think, just to be clear about, again, the difficulty of these options, the grievance hearing win, I think that you have a good chance with an attorney in many cases. But once you lose, or if you're denied the ability for a grievance hearing, which we will get into, the writ itself, there really isn't any assistance on. There's nobody doing pro bono writs. It's very difficult. I think most of you as attorneys would know that the barrier to access to writing your own writ is quite high. The barrier to access to attorneys who don't write writs is quite high. They're very fussy, and there's no form. So like in some instances, appeals, like the appellate process, is made easier for individuals by like a production of forms. But I think there would be a high likelihood of procedural errors that could generate writs that were successful, but there aren't a lot of people who are doing those, and certainly no one for free. And most people who are listed on the CACI are going to match who's investigated by child welfare. And just to give you guys like a stat from 2022, a large report found that, you know, more than 80% of families who were investigated by child welfare were 200% below the poverty line. So the chances of having someone to pay for a writ are pretty low. And if you look at not that I expect you to look at CACI case law, but if you did, CACI case law is often driven by wrongful investigations of people who actually had money to challenge it. So this is one other weakness in attacking this system judicially. If you happen to get somebody on the CACI in their timeline, the first thing that can be done is actually talking directly to the investigating agency. Occasionally, people are just put on for reasons that make absolutely no sense. So it's a mistake. It should have been the other person in the case. In those cases, most child welfare agencies will look through the record first just to make sure that it isn't like they can take you off at any time. They can change the substantiation themselves. The way that they do take you off, like the only way for a child welfare system to take you off is for the substantiation to have changed. So it isn't, they have to go back in their records and to the investigation to say whether or not, like, an untoggle substantiated next to severe neglect or child abuse and make it inconclusive or unfounded. There isn't, like, they couldn't look back at it and just say like, oh, I just don't think this is very fair. They literally have to change their referral. They have to, and for in some cases it really was just an error, and they do like drop it right away. So you can talk to the person who administers the CACI and say, do we really need to have a grievance hearing over this, for example? Or they might tell you, no, you have to have a grievance hearing. If you are an attorney within dependency court, what you would do about the CACI is try to make amendments to the petition. That's our charging document. So you want to change anything that is higher than a neglect charge into a neglect charge, which would be 300B, and try to remove any intent or willfulness language. The reason for that is that if you get whatever you get in dependency court as your petition and whatever you get in criminal court if it matches what was substantiated in the referral that put you on the CACI, you will be barred from having a grievance hearing. So for example, if your criminal lawyer makes a decision or is talking to you without really understanding the CACI and thinks, well, here's a really good deal, and doesn't understand that you would be barred from challenging. So like basically if you get one of the charges that has anything to do with the child, even if it's a lower punishment than another one, you're going to be barred from the grievance hearing. If you look on the letter that I sent you guys, that's the collateral consequences letter, that describes sort of in detail, like this is an example of what we send to the DAs through the public defenders in order to ask to be removed to the CACI. We've had a lot of success with collateral consequence letters, because for the DA, it's not taking you off the CACI, it's giving you an opportunity for due process. Most attorneys find the entire process of the CACI so draconian that they're actually willing to negotiate in this area and at least give you the chance of defending yourself. So if certain parts of the penal code are checked off as your charges, you just won't be able to defend yourself for the CACI. And a lot of these come with no sentences, or you're in the community. Many people who are put on the CACI don't have their children removed ever. So you're also putting people on to the Child Abuse Central Index without, like, in a way that affects their ability to parent, while the state has found you to be a sound parent for your individual child. So that is one of the things that is very confusing for people who have been listed on it. Independency, if there's language around, it's the same issue as the criminal. If your charges, or what we would call independency, your allegations, match the underlying substantiation, you will be barred from having a grievance hearing. You can writ being barred the grievance hearing, but if you remember what I said before, there aren't any attorneys who are doing pro bono writs. If anybody in this webinar is dying to do a pro bono writ, please contact me afterwards and we can talk about it. I would appreciate that. But because we don't have people doing pro bono writs, it creates this, it's as if that's not a real remedy, because the chances that somebody 200% below the poverty line is going to be able to write their own writ to challenge this grievance hearing are pretty low. The other thing that's really important to understand about notice, which I hadn't said originally, is that usually when people are the process I described for which you get listed on the CACI, usually the CACI is not the worst thing happening in your life when this process is happening. Most people who are going to have visits by the police or child welfare, for things that would get you listed on the CACI, like that is the worst thing going on in your life. You might be going to jail, or someone might be removing your children, or both of those things might have happened. So the other issue with notice is a purely human one, which is that sometimes notice actually does arrive and you are not in the state to understand or process or even look at that mail. And again, as everyone probably understands in our own life, mail has decreased in importance culturally and materially for people everywhere. So like the chances that you are combing through your mail when everything is happening by phone calls, like the child welfare system is calling you, they're telling you, they're delivering paperwork to you. They're not just sending a random thing in the mail that decides whether or not you're keeping your children. So the grievance hearing, this is the part that, getting back to someone's original question, you have to, within 30 days from receipt of that notice or first learning about the CACI, you must submit the 834 report, the 834 paperwork, or you could just do this manually, but it's easier to have a form. You submit it to the agency. It'll say at the bottom of the form who to give it to, but if you were confused, you could always call your county welfare agency and ask who is responsible for administering the CACI, so that you were able to say, I'd like a grievance hearing, and I'm requesting it in writing. When I say first learning, one good thing about the notice is you do have to get it. So if you have somebody who appears and said, I had no idea that I was on the CACI, I went to my child's school and I got hit in this background check, I don't even know what the CACI is, this is a thing that happens. In those cases, as soon as they know, they can contact the child welfare agency most likely to have put them on the CACI and say, hi, I'd like a grievance hearing. I just learned that I was on this. I had no notice. And I haven't had any issues getting cases under those like getting a grievance hearing under those circumstances, as long as the person themselves wasn't barred from their charges. So if somebody calls you and tells you that their charges, whatever charges they tell you actually would match the CANRA definitions, then you're not going to get a grievance hearing, but you wouldn't have gotten one anyway. The due process issue here, if anybody has like a bingo card where you're tracking all the due process issues, the due process issue here is that you might have agreed to dependency charges or criminal charges that made sense for your life then, with no idea that the ramifications of that were a listing on the CACI that you would not be able to argue with. This happens a lot in dependency cases and in criminal cases where people are thinking about, they're weighing different outcomes and they're not really understanding collateral consequences. And in this case, their attorneys are not responsible for understanding that either. So I know a lot of you probably know that there are certain immigration consequences that public defenders are supposed to be able to explain to their clients. There's no analogous requirement for the CACI. So a lot of times people are making decisions that make a lot of sense for their court cases in dependency and criminal that wouldn't make sense if the CACI is going to end up being a real burden for the client. When you're actually filling out the 834, if you look at it, you always check the part that says that you want to inspect the records. That's your discovery. And then the actual county, if you ever decide to do a CACI case, they're going to ask for a release of information for you as an attorney to inspect. So remember I told you that they will immediately send a rejection to you if you haven't been adjudicated in criminal or dependency court for the underlying referral. When that happens, they send back something that says to the client, like, sorry, like you can't have a hearing, you haven't had adjudication in your court case. They do not always explain in those notices that you have to re-ask. So you have to, within 30 days, like you get another 30-day timeline. So once jurisdiction is found at dependency, or there's been a ruling on your charges in criminal, then you need to, the 30-day time clock starts again, and you have to ask then for a hearing. This also includes, just for people who are just keeping track of the things that are complicated for clients, if you have a diversion, you have to wait to the end of your diversion. So if you are in veterans court, or you have a drug court diversion, or primary caregiver diversion, you have to wait to the completion of your program, because if you remember, like the criminal court is not going to make a decision on your charges. They're just sort of held. And then the decision on your charges will come after you finish the program. So if you have, which means you will be on the CACI for all of that time without a way to get out of it. So that is something people have, I think that mostly people would weigh it as, I'd rather lose my job right now and then try to get it back when I'm done with my diversion than going to jail, which I think is exactly what people do. But keep in mind that you will be listed during that time. The grievance hearing, if you look at the policies and procedures, these are just some of the things to know about them. The agency will schedule it within 10 days and then hold it within 60. The notice of the date has to be within 30 days of the hearing. There's 10-day continuances are granted pretty much for any reason. It's good cause or agreement, but like there's a lot of leeway there. Discovery is given to you. Well, here's the rub if you're a trial lawyer. Discovery is given to you 10 days before, but you also need to turn in your witnesses or evidence 10 days before, which is very difficult. I haven't had any issues with asking for an agreement from the parties for an extension there. And I've never had an issue with the hearing officer because of that, because there has been occasion where I want to call witnesses from within the discovery and make a decision before I'm putting them on a list. Settlement without a hearing can happen at any time if the agency changes from substantiated to inconclusive. So they are willing to, in many jurisdictions, discuss this beforehand, because it's better to discuss it than go through with a hearing. You get a written decision within 30 days of the hearing, and then you have 90 days to writ. For those of you who have ever done anything in dependency, our writ timelines are very short. So this is a good amount of time to do a writ. Not for an individual, of course, but it's still a better deadline than most people have for writs. The grievance hearing format is one of the weirder things. This is what I hope I would love to encourage people to actually do the grievance hearing as part of this. The CACI is a very so I'm gonna do my pitch for you guys doing CACI hearings. CACI is a very, very narrow area of law, so you can become essentially very well versed in it quite quickly. It's a small chunk of the penal code, and then the manual of policy of procedures, which is part of your handout. That's the sum total of the procedures that you face. The person who adjudicates the CACI hearing, like many administrative hearings, it does not involve a judge. The agency assigns a senior social worker as a grievance review officer to conduct. They need to be, here are the things they have to be. They have to be knowledgeable about child welfare, capable of conducting a fair and impartial hearing. They cannot be a coworker or supervisor of the person who investigated the referral, and they cannot have been involved in the investigation or findings. Some jurisdictions will have social workers from other agencies come in. Most of these hearings post-pandemic are conducted online. So in fact, most of them are conducted through Microsoft Teams. So just another plug, you could be representing someone from the comfort of your own home in a CACI hearing. So the review officer issues, there is a little case law on people who've challenged specific review officers. I think the response to this has been to just have there be people who do this as a review officer and have nothing to do with investigations anywhere. Notice that there isn't like a high requirement about penal code. So I haven't been in an experience where there's a lot of misunderstandings about the penal code, but it is very difficult to make certain kinds of legal arguments to a senior social worker. So one thing that has been difficult is to make, and this is why writs are an important avenue of attack that we are not fully taking advantage of as CACI defense people. The one thing that's very difficult to explain to the administrative hearing person is all of the issues around being able to have a grievance hearing if the charges are similar. So like you are almost never charged with something that's completely analogous to the penal code, unless you're talking about sexual abuse, because under Welfare and Institutions Code 300D, which is the sexual abuse code, it matches very closely with, in fact, it references the penal code, and then CANRA, the statute in the penal code for child abuse reporting for CACI, matches that definition as well. So that's the one area in which everything is pretty inarguable. When we're talking about, for example, excessive physical discipline, the wording, like you have to be arguing to the social worker that in fact the legal standards are different in the 300B, even though this wording looks similar to the penal code. And you do not have judges saying in dependency court or criminal court, this doesn't match, this isn't matching the CANRA, or it's not meant to match the CACI standards. So you're not getting, like, they don't care about CACI. Like you would have to make everyone in that courtroom care about CACI, and they might if you have an attorney, and keeping in mind that your defense attorneys in dependency court and in public defense in criminal court are not required to care about it. And keeping in mind also that in California, there's very little investment in public defense in dependency court. So you're usually getting people who work in multiple jurisdictions and multiple courts who are working on a panel. So it is actually pretty difficult for them to also be doing CACI for their clients. Parties have the right to call witnesses, testimony under oath, recorded hearings. You can submit documentary evidence. You can inspect the evidence of the other party, obviously. You have to exchange your witness lists. There's no subpoena power, but again, continuances are liberally granted. The standard for everything is preponderance. I think one thing that's important to understand here, if you are a dependency attorney contemplating CACI, is that the evidentiary rules are pretty lax in favor of getting the evidence in these hearings. So there's a large amount of documentary evidence that comes in that would otherwise be excluded. Issue spotting. The first is, should this person actually have been listed? The erroneous listings. Here's a case that you can look in for there. There's also cause of action for 1983 for damages and relief for these listings. That's tried in Los Angeles v. Humphreys. The second is, was there an active investigation conducted? So you're looking for errors in the investigation. You're looking to see if CPS relied on law enforcement instead of doing its own independent assessment, for example. The next is, does a criminal defense apply? So again, this is the parental disciplinary privilege, a lack of mens rea or intent requirement. And there's really, really good language in Gonzalez, which I put in here, which is why I'm taking you through it. The definition of severe neglect and willful versus intentional is we're given like a real boost by Gonzalez, where it says, in its plain and ordinary sense, accidental means arising from extrinsic causes, occurring unexpectedly or by chance, or happening without intent or through carelessness. There can be no doubt that mother's conduct in that underlying case, striking her daughter's buttocks with a wooden spoon, was intentional. The resulting bruises, however, the only injury, even arguably involved, appear to have been an accident in that they happened without intent and at most through carelessness. So if you are doing severe neglect, this is what you would be reading to the administrative hearing officer and asking for them to consider that, in fact, like, this is, it really helps to overcome what I mentioned earlier, that wanton disregard for willful, right? So you're saying, but look, Gonzalez clarified the standard. I would say that it's less helpful for cases where we're not talking about parental discipline. I've still used it in those, but for example, people have been put on the CACI for DUIs while their child was in the car. If a cross report is made to CPS, and in a lot of cases they aren't, but in those cases, it's really difficult to overcome, in my experience, wanton disregard. Again, here's the writ. Please let me know if you want to do writs. The confidentiality issues, just in case anyone ever was going to do one, you can request initials. Otherwise, it's not confidential, which is important for people to know, because a lot of times anything involving children, they're expecting the same sort of privacy as dependency court, but it wouldn't be the case. You have 90 days to file. The issues are pretty general writ ones, like the investigating agency acted outside the scope of its authority, the investigating agency abused discretion, or procedural errors. The court must exercise independent judgment to determine whether the evidence establishes that the report of abuse or severe neglect is substantiated. It has been held to be an error for the Superior Court to apply a standard of substantial evidence, and the case is below there. However, on appeal from a denial of a writ by Superior Court, the Court of Appeals upholds the trial court's finding if it is supported by substantial evidence. Again, all of these things would be great if we had people writing writs. And then I think this is one of the most important slides and our concluding one. It is really, really important for people to understand that CACI is an indicator and not a judgment. So the system that I've just described to you it's extrajudicial, you have no attorney, you're put on the list before you're able to challenge it, and the decisions that are made in dependency and criminal court will determine whether or not you get to go forward in dependency court. So all of those things make this a really difficult registry to get off of, not even coming to the part where there's no real expungement. What's important, as it's an indicator, is that you do have a chance to challenge decisions made by people denying you a benefit or right because you are on the CACI. So the first thing to know is that the entity getting CACI info through a background check is responsible for obtaining the original report from the reporting agency. So remember, the DOJ doesn't have the report. The DOJ is the person that tells them whether or not you're on the CACI through the live scan. Usually, it's best to just keep in mind if there's a live scan, that's when CACI is going to come up in almost all cases. So they're responsible for going to the child welfare agency, so let's say the school, and getting the original report. Then they are supposed to draw independent conclusions regarding the quality of the evidence disclosed in that report. And then third, there has to be sufficient information for making that decision regarding employment, licensing, RFA, I'm sorry, I shouldn't have used that, is resource family approval. So when you're approved to take a child, they have to have enough information. Occasionally, I've heard cases, I haven't had one, but I've heard cases where the underlying report is not kept in good enough condition, or it's not there, or there's some issue with it. They shouldn't be allowed to make a decision based on your employment or licensing or RFA at that point if they don't actually have a full report. An entity receiving CACI information is not supposed to act solely upon the fact that you're listed on the CACI. So that's the part that you're really supposed to drill home when you're requesting to go forward with some kind of hearing about being denied the benefit of the right. Again, just to say, like, in situations where it's really sensitive for the person to be listed and the benefit or right is very low, for example, volunteering to carpool for their child's school, they might not want to go through all of this, because of course a school community is much smaller than asking for an RFA, for example, or asking for some kind of licensing. That is a large bureaucratic process that doesn't involve individuals you know. When you are trying to challenge the like benefit or right of volunteering at your child's school, you are having conversations with them about things that they might have no idea about, and you know, are potentially embarrassing. So that's what we want to counsel people on. The actual person trying to challenge it should get the underlying reports and craft a defense narrative for the hearing, with whoever defines you the benefit for CACI. And I think that's the end of my slides. Let me see if there's any, probably Q&A. No, there's no statute of limitations. The way that you change, if I hadn't gone over this, the way that you change your substantiation is to ask the child welfare department itself. You have to be able to go to them and convince them to change it. So the process for that is either negotiation before your grievance hearing or the grievance hearing itself. Theoretically, how can the court actually adjudicate on an allegation without evidence? I think this is like if you just learn you're on the CACI, I'm answering Ms. Beal's question. If you just learn that you're on the CACI, then you go through the petition process the same way. You go to the county and ask who's administering it. You say, I had no notice of the CACI and I would like help with the CACI. Sorry that I didn't see there were so many questions. What if there's no notice of CACI when a report will be made? If you don't get notice, you are allowed to challenge as soon as you find out that you've been put on it. So as I told you, a lot of people realize that they're on the CACI because they go to do something and they're suddenly told that they're on this registry. They've never heard of it in their life. In that case, they can get the same as the question that appeared before that. In that case, they can go directly to the child welfare agency and say, hi, I was listed on the CACI. I've never had notice. I would like a grievance hearing. If they're in a situation where their criminal case or the dependency case bars them entry, I think that's a really good writ. And again, if anyone's excited about that, let me know. And let me see. I've heard they make decisions substantial or unfounded. What if they don't tell the client the finding of substantial finding? People often don't know that they've had a substantiated referral for severe neglect or abuse. The only way they can know they're on the CACI if they got notice. There's no other way to know that you've been put on the CACI besides asking the DOJ for a self-inquiry. So if you have a suspicion you're on, you can do a self-inquiry, and the minute you find out, you can again start the process of challenging by saying you didn't have notice. I think, let's see. And one other thing, and then I think we're done with our webinar, but if someone suffers a loss and dependency is entry mandatory, know if your petition allegations doesn't match the actual allegations for the penal code. So it isn't mandatory, but you might end up in an argument with the county over whether or not you're entitled to the grievance hearing. Anyway, thank you so much, everybody, for coming. I really appreciate it. Please let me know if you are excited and want to defend people in the CACI. I am happy to help people do that.